UK employer and you're relying on the 2-year period to manage risk, the safety net is shrinking. The Employment Rights Act 2025 changes the way employers need to think about hiring, probation, performance management and exits, because unfair dismissal protection is moving to a 6-month qualifying period. And that one change alone will force many businesses to tighten their employment foundations. Today I'm going to cover what the Act changes that employers will actually feel, what timelines you need on your radar, and what to fix now in contract and in process so you're not firefighting later. So let's talk about the big change, unfair dismissal after 6 months. Historically, many employers have treated the first 2 years as the period where you can course correct quickly if someone isn't right for the role. Under the Employment Rights Act 2025, that risk window tightens significantly because the qualifying period for ordinary unfair dismissal reduces from 2 years to 6 months. What that means in real life is that you will need to take probation seriously, you will need to document performance issues earlier, and you'll need to be more disciplined about process even for relatively new hires. And there's a second kicker. The Act also provides removal of the cap on compensatory awards for unfair dismissal. So the cost of getting it wrong increases at the same time as the qualifying period decreases. That's why this matters. So let's talk about fire and rehire, contractual change dismissals, and where employers get caught. Changes around dismissals are linked to forcing contractual changes. One of the Act's core themes is reducing fire and hire style tactics. In particular, official materials state that dismissals for failing to agree to a change in certain core contractual terms are treated as automatically unfair, except in a narrow scenario where businesses are in severe financial difficulty and genuinely have no alternative. This is a big deal operationally because businesses often need to adjust terms, hours, duties, location, pay structures, especially when scaling or restructuring. The lesson here isn't never change your employment terms. It's document the business rationale, consult properly, consider alternatives, and don't treat termination as the default lever that you can pull. So what must employers change now? Let's get really practical here. If you employ people, here's what I would be tightening up now. Firstly, probation that actually functions. Many probation clauses are decorative. They say 3 or 6 months and then nothing happens. You want probation objectives in writing, scheduled review points week 4, week 10, week 20, clear extension mechanics, and a documented decision. Because if someone hits month 6 and you've got no paper trail, you're exposed. Performance management has to come earlier, lighter, and be documented. You don't need a tribunal level paper mountain. You need clear expectations, 1 or 2 written check-ins, training and support noted, and a record of what didn't improve. Termination process light. With a 6-month qualifying period, more exits will fall within a zone where process matters. Build a consistent light touch approach. Meeting invites, brief notes, right to respond, and confirm decisions and pay or notice. Contract hygiene. Fix the clauses that break first. Most disputes come from the same weak points: job scope that's too vague or too rigid, mobility and flexibility clauses that don't match reality, poorly drafted notice provisions, and inconsistent policies. Get those all aligned. Employment status and contingent workforce risk. Why this Act increases buyer scrutiny. Another area you should be dealing with is deal risk, employment status, and contingent workforce. Even if a reform isn't fully felt day one, buyers and investors respond to the direction of travel. There's been clear public focus in commentary and reporting around tighter approaches to things like zero-hour contracts and worker protections under the Act's broad reforms. So why does this matter? Because due diligence teams don't just ask, are you compliant? They ask, is there a latent liability here if the rules tighten or enforcement increases? So if you've got long-term contractors who look like employees in practice or casual arrangements that are effectively permanent, that risk is now a lot more expensive. So let's talk about implementation dates and planning. Timelines matter. Different provisions of the Employment Rights Act are coming into force at different times, and there are commencement regulations and transitional rules already in play for some areas. Separately, for unfair dismissals, Credible summaries and official fact sheets indicate that the 6-month rule is tied to a forward implementation point, with 2027 referenced in multiple summaries, so employers should treat 2026 as the preparation year. So what does good look like? What is a simple operating model? If you want a simple internal standard to protect the business, here it is. By week 4, role expectations and first check-in should be documented. By month 3, formal probation review outcome recorded. By month 5, if it's not working, you're either providing evidence or planning an exit with process. By month 6, you're not making first-time decisions, you're confirming decisions. That's how you stay ahead of the new risk profile. The Employment Rights Act 2025 is pushing employers towards stronger discipline in hiring and management, earlier documentation, clearer process, and better contract hygiene. If you want us to review your templates, rebuild probation and performance processes, or stress test your termination risk under the new framework, book a call with us today. You'll find the link below this video.